ongoing political debates over more coronavirus relief funds has included some talk about special liability protections for businesses. Here to help make sense of all this, Tom Sinus of Sinus Dramus Law Firm joining us as he does every week. Tom, talk about how does the law in this area work currently, I guess?
So I hear a lot of talk in the news, as do a lot of people, about liability protections for businesses and coronavirus, either at the federal level or the state level. And it occurred to me, well, wait a minute. Before you talk about that, maybe we should remind ourselves, how does this law work without those protections? And that's really a review of what we call negligence law. So here's the basic principles that apply to any negligence claim. The first is that the victim and the defendant has to have some kind of relationship. The law calls that a duty. It imposes the duty then on the defendant to act in a particular way. Well, what is that particular way? Well, the law says that everyone who owes a duty to someone else must act reasonably. If you fail to act reasonably, then you've committed what the law calls negligence. Negligence just means a failure to use reasonable care. And the third hallmark element of any negligence claim is what the law calls causation, which means proving that the harm was in some way caused by the defendant's actions or the defendant's failure to act. So these are principles that apply even as the law as it exists now. And I think it's important to remember them as we talk about whether we're going to change the law in this area.
Yeah, how would liability protections change the current law, speaking of which, Tom?
Well, it depends, of course, on what you're talking about, state or federal, and this is constantly changing. But the basic idea behind these liability protections is to increase the standard so that the victim has to prove something much higher than a failure to act reasonably. For example, the victim may have to prove that the defendant intended for the victim to contract the virus, or that the defendant acted recklessly or with disregard to public safety. So these are very high standards. And I think as people are thinking about how they feel this way, ask yourself the question, well, how challenging would it be to prove a quote unquote coronavirus case under the old law? If you're in an establishment that's taking reasonable steps to protect its patrons, then there's no liability for the establishment. More importantly, the plaintiff in any case has to show causation, that they can prove that they somehow contracted the virus at that particular location. And boy, that in and of itself is a real challenge. So those are the principles that exist now, and changes of them would just mean that the plaintiff has all that much higher of a burden of proof to overcome, or a standard to overcome, to pursue a claim.
All right, Tom, good stuff. How do people track you down that need more information on this topic?
You can find us online at www.sinusdramus.com. Shoot us an email at info@sinusdramus.com, or give us a call at 616-301-3333.
All right, good stuff. As always, thanks, Tom.
Thanks, Derek.